Hi, good evening. This is Kenya Rockman, the author and founder of the Child Support Hustle. And I am going to talk about, I put in the comments what I'm going to talk about this evening. Let me do the only comments. Comments are able. Okay, so I'm gonna add the comments. Hi, Isla. I'm sorry if I'm mispronouncing your name, but hi, thanks for joining. Hi, Fisher, Kyle Fisher. Hi, how are you? I'm doing this live discussing. I want to discuss this Federal Register that came out in 2016 and the changes that they are trying to implement across the country in regards to incarceration being considered voluntary unemployment. Okay, so I'm gonna give you a background about the original Federal Register and what it said, and then I'll discuss why changing this is a horrible idea. Okay, so in December of 2016, the Flexible Efficiency and Modernization in Child Support Programs final rule was published by the federal government. And if you go to the childsupporthustle.com, I've written about this, I've done videos about this Federal Register as it deals with ability to pay and this making incarceration not considered voluntary unemployment. So the purpose of the publication was to make the child support program operations and enforcement procedures more flexible, efficient, and effective. And they want to do this by building the strengths of existing state enforcement programs, recognizing advancements in technology, and incorporating technical fixes. The final rule was intended to improve and simplify program operations, remove outdated limitations to program innovations. Now I want you guys to notice that this publication about the child support system and just what I broke down never mentions the best interest of children. And this is, I'm taking this verbatim, and as always I put the links in the description. So I want you guys to go and look up what I'm talking about, so you have full-on knowledge and you have resources if anybody asks. So I'm going to ask you guys to contact this agency later on. Hi Lynette, hi Ray, hi Josh, prayers to you as well. Hi Frazier. I know who you are, but I don't know how to pronounce your name, and I'm sorry if I butchered it, but how are you? Good to see you on. Thanks for joining me, everybody. If you could take a second and click the share button, I would be grateful forever. Okay, so the latest changes revised the guidelines for how child support orders are supposed to be set. These changes are supposed to ensure that child support orders are based on actual income and ability to pay, and not imputed income. That is very important, because imputed income in this Federal Register, they set out a whole list of criteria that states are supposed to consider before imputing income. So they can't just go by what your age is, what you're supposed to be making in your geographic area. It's a whole list. And again, I've done a video about this list and everything. So check it out. If you are getting a new order and they're trying to impute your income, or if that has happened in the recent months, then even years, the recent years since 2016, then I would challenge that order amount if it's based on imputed income. Okay, so based on the final rule, the state prohibited the treatment of incarceration as voluntary unemployment when establishing or modifying a child support order. The main reason for this change was not to benefit the non-custodial parent. Let's be clear, they never do anything to benefit the non-residential parent, but to remedy the fact that states that have policies that treat incarceration as voluntary unemployment effectively block application of the Federal Review and Adjustment in Section 466A10 of the Social Security Act. So they're violating the very act that this child support enforcement program is supposed to be legalized under. So by them not considering incarceration involuntary unemployment, they're violating the Social Security Act. That's where all of this comes from, is under this act. That's where they get their incentive money, under Title 4D. That's where all this comes from. So the states are violating that act by treating incarceration as voluntary unemployment. Specifically, all parents facing a substantial change in circumstance, such as a drop in income through the loss of employment or otherwise, are entitled to request a review and, if appropriate, adjustment to their child support order. That's in the law, the act. According to the federal government, incarceration qualifies as a substantial change in circumstance. Yet the states, rooted in the 19th century jurisprudence, treated incarceration as voluntary employment, which blocked the application of statutory review and adjustment provision. So once again, states are breaking the law, violating the guidelines. You know, if you're not new here, you know I don't call the child support system anything written there laws. Hola, Christopher. Thanks for joining. Oh yeah, I have shirts available. I'm gonna say that now since I just read Christopher's comment. You can order this at the childsupporthustle.com, and of course you can get a copy of my book, The Child Support Hustle, online, and it's also available in an ebook. So you can get all those on the website. Hi Mike and Dion. Hi Josh. Okay, so this meant that child support orders were unrealistically high, resulting in undermining stable employment and family relationships upon release. It encourages participation in the underground economy and increases recidivism. I think I said that right. Okay, so studies show that incarcerated parents leave prison with an average of $15,000 to $30,000 or more in unpaid child support, with no means to pay upon release. This is why this is so important. They already did the studies, the research, and it doesn't take a rocket scientist to know if you are indebted to anybody about anything and you do not have an income and it's not adjusted accordingly when you are able to make a living, that debt is going to pile up. I mean, that's just basic. So, okay, due to this, the federal government revised 3038C of the final rule that states implement reasonable standards developed for purposes for review and adjustment, so that the incarceration is not treated as a legal bar for petitioning for or receiving an adjustment of an order. I know this is kind of, it is horrible. Hi, Johnny. I don't know if you got everything straightened out. I sent you a form. I hope you did. And thank you for your continued support. But I have to do the background so I can tell you. Yeah, John, that much. This is based on the research that the federal government conducted. They already know everything about this. But okay, I'm sorry. So it's a case out of Indiana, the Indiana Supreme Court, Lambert versus Lambert, said incarceration does not relieve parents of the child support obligation. However, on the other hand, in determining child support orders, courts should not impute potential income to imprisoned parents based on pre-incarceration wages or other employment-related income. Orders should be calculated based on actual income and assets available to the parent. And so in other words, if a parent is earning $0 a month, that is how the child support order should be written, or that's how it should be determined, the monthly amount. That's how it should be determined. You're welcome, Johnny. So the rule does not provide special treatment for incarcerated parents, but it does require application of federal review and adjustment requirements. This includes that orders be reviewed and adjusted upon upward or downward in all cases upon showing that any substantial changes of circumstances have occurred. This includes changes due to unemployment or incarceration. Implementation of 302.56C3 ensures that states consider incarceration as substantial change in circumstances warranting that child support order be reviewed and, if appropriate, adjusted based on the parent's ability to pay. If the non-residential parent has assets and incomes, those can be considered in the review. Okay, John. If you leave, you don't have to announce it. I'm sorry. That was funny. Okay, so again, states should not assume ability to earn based on pre-imprisonment wages, since incarceration typically results in a dramatic change in drop in income and ability to get a job upon release. I'm sorry, guys. Revolution is right. Okay, so the federal government said that the child support system is not meant to serve a punitive purpose. The system is an economical one. Okay. Evidence has showed that imposing high child support payments on incarcerated parents serves as a punitive measure, becomes an additional collateral consequence of incarceration, does not serve in the best interest of children. Finally, we hear about the best interests of children does not serve in the best interest of children by damaging the parent-child relationship and damages the prospect for consistent child support payments in the future. Okay, a report released in 2005 by the Council of State Governments identified child support obligations, especially arrearages, and we know about those arrearages, as a barrier to successful re-entry into society because they have a tendency to disrupt family reunification, disrupts parent-child contact, and disrupts employment patterns of formerly incarcerated parents. Hardly, that depends on your state. Sometimes it extends after 18 if the child, adult, by then goes to higher education. So if they go to college, some states will make you continue to pay. And if your child has a disability or is a special needs person, adult, they sometimes will make you continue to pay child support, but it depends on the state. Okay, so now I lost my place. So now I get to this new guideline where they're trying to get exceptions to everything that I just said. They listed out reasons why they incorporated this change to say that incarceration cannot be considered voluntary unemployment. But now they are trying to make an exception to this rule that if a parent is incarcerated due to intentional non-payment of child support, that should be considered voluntary employment. And any offense in which the parent's dependent child or the child support recipient was a victim. For the purpose of this video, I'm only talking about the intentional non-payment for child support. Okay, of course, any violence against children or anybody is reprehensible. So I'm not going to even discuss that. But I will discuss this other part and the reason why I'm doing this video. Okay. The federal government feels that this change is appropriate because the officials feel that very few cases would be affected, and these will provide states a narrow window of flexibility to address egregious cases of willful child support non-payment. Now, when we consider this word egregious, and we all know that people get locked up for child support debt across this country for hundreds of dollars. even thousands of dollars. It's very few cases where where the debt is into the hundreds of thousands of dollars. So then we have to look at the definition of egregious. Excuse me one second, guys. So we have to, and I'm going to give examples of even after 2016, and we can go back even further to Turner versus Rogers, the Supreme Court decision of 2011, where ability to pay must be considered before they even have a contempt of court hearing where a parent is going to be jailed. So when I think about the fact that the states are going to be allowed to consider incarceration as voluntary unemployment, I think of cases like Felix Manis, who was sentenced to work release program in Erie, Pennsylvania. And that was in 2018. He was serving time for allegedly owing $750. Yes, Isla, I'm sorry so much, but yes, it is. $750 in child support debt is why he was incarcerated. He ended up having an asthma attack while he was on this work release. He didn't get the medical attention he needed, and he died. That was in 2018. That was, like I said, 2 years after the Federal Register. So the courts already didn't follow the guidelines where he shouldn't have been in jail in the first place, because they did not offer him a hearing to determine his ability to pay, and they locked him up anyway. So if they change this guideline, more parents are going to be locked up because of failure to pay child support without their due process rights, and then while they're locked up, the child support debt is going to continue to accumulate. So we're going to move on, because this is not the only, that's one example where someone died. In Rusk County, out here in Texas, they conducted a child support roundup, or they do these mass sweeps. They do them all over the country. From time to time, they have cute names like Operation Deadbeat Dad, or Operation Father's Day, or you know, a little shit like that. Excuse my language. But in Rusk County, on February of this year, they arrested 11 people for child support. There's no mention in the article about anybody being offered any rights to due process. Yeah, even in Pennsylvania. Pennsylvania is really bad. They're all real bad, but Pennsylvania is one of the worst that I've seen, just based on my research and talking to parents all across the country. Pennsylvania is one of the worst with the child support issues. Florida's up there too. Michigan is probably, well, they're all bad. I'll sit here and be like, well, Michigan, but then you gotta look at Texas. But Cali's Cali pretty bad too. I agree, John. Okay, so in February of this year, again in Lafourche Parish, Louisiana, I'm probably not saying that correctly, 11 people were arrested based on the DA Christine Russell, who said, and I quote, "The arrest had less to do with the amount owed and more to do with the lack of effort to make payments." Nowhere in that article did they say anything about hearings, ability to pay, any safeguards being offered. And if the willfulness is not to pay is not supposed to, and if the willfulness to pay is not egregious, I'm going to start that over. And if the willfulness to not pay is supposed to be egregious, that determination must certainly be reached by considering the amount of child support owed. So, okay, that makes sense to me now. When I do, I take my notes and stuff, and sometimes when I go back to read it, I'm like, wait, that doesn't make sense. So, if the reason that a parent is going to be locked up based on these changes that they are making is because somebody might be egregiously failing to pay child support, and in Louisiana, she's saying, the DA says that it doesn't even have anything to do with the amount owed, that's a contradiction. And they're going to lock you up. Okay, so then June 2020, and this is after we are affected by the COVID-19 pandemic, which resulted in record numbers of unemployment. Not only did they not cancel child support payments, it's taken parents months and months to even get a modification, in which they can deny the modification. So with all that considered, after that, North Carolina, New Bern, North Carolina, conducted a child support sweep arresting 27 parents. Proof that most parents arrested did not have the money to meet the obligation. You can see that in the amount that was collected after the arrest. The amount that was allegedly owed by the parents was $165,000. They only collected $25,000 after these arrests. So that clearly shows that they did not hold any hearings to determine ability to pay or anything like that. And the stimulus, we're not even going to go there. That was just robbery. I can't describe it with any other word. Theft, but that's the same thing as robbery. And I would, if I was parents that had their stimulus taken, I would get with other parents and file a class action lawsuit. They weren't entitled to that money at all. And side note, for the custodial parents, if you received any public assistance, I'm almost guaranteeing that you didn't get that money. So that went straight to the government. That's a whole different issue. The child support hustle is real. So the Children and Family Administration is attempting to revise 302.56C3. That's what I was talking about in the beginning of the video and what I'm talking about now. So this revision would allow state the option to adopt limited exceptions in their guidelines to the regulatory prohibition against treating incarceration as voluntary unemployment. It applies to incarceration for non-payment of child support resulting from a criminal case or civil contempt action in accordance with guidelines established by the state. The state would be able to apply the second exception if the individuals, this is a tricky one, they're all full of tricks, if the individual's other child support cases, to the individual's other child support cases. So if you're incarcerated, they're going to go back and apply, yes it is, Brad, you're going to get charged for each one. Even if you're not in jail for that particular case, if you have more than one case, they're going to go back and say that you're voluntarily unemployed on all your cases, not just one. That's bullshit. Excuse my language. Okay. States and not the federal government are the best position to decide whether or not it is prudent public policy to afford relief from child support payment obligations for individuals who are incarcerated for intentional non-payment. Now we know the states should not, because there's no accountability, be in charge of anything to do with the child support system. You give them this authority, they're going to ignore everything and treat everybody the same and charge everybody and change it to everybody that's in jail is getting more language, please. I'm a lady, but I cuss a lot. You guys stop, because then I lose my place. And I'm already not good at the live videos and stuff. I'm working on it, but I'm always a work in progress. Okay, so the federal government says that the states are arguably knowledgeable about their caseloads and how decisions affect families. And they should have the option to apply this prohibition against treating incarceration as voluntary unemployment. We all know that's a problem. So I argue that the states regularly disregard pertinent information concerning the families, especially the financial information of the non-residential parent. They should not be permitted any exceptions to consider incarceration as voluntary unemployment. In a study by the NDRC, caseworkers admitted to being subjective instead of objective in determining which cases were to go to the court for contempt hearings. They were looking at Facebook, social media posts, and things like that, and seeing what somebody had or what they looked like they had. And everybody knows on social media, people stunt. Just because somebody put in stunt, meaning, a lot of people pretend. So just because somebody posts that on social media does not mean that's what they have in real life. So for these caseworkers, and this is a study, I put this in the notes too, for caseworkers to look at social media and decide, oh, he going to jail for contempt, or she's going to jail for contempt, is unacceptable. That is not how they are supposed to decide, and this is per the Supreme Court, which cases are referred to court for contempt proceedings. By allowing states to incorporate this exception, they are going to be allowed to ignore the ability to pay rule once more and charge parents while incarcerated. So here's the call to action. Since these are proposed changes, we are permitted to submit comments as to why or why not we think these changes should or shouldn't be implemented. And I already went through all the reasons why, and I'm sure you guys, I can't read all the comments, but I'm sure you all have reasons why this is not a good idea. This is going to put parents deeper in debt when they are incarcerated, even if they are in jail because of contempt of court for not paying child support, especially with unemployment as high as it is because of the coronavirus. So the call to action is to submit a comment about this proposed change to the federal government. And I'm going to give you the information, and I'm also going to post it in a comment when I get finished with this. But I'm going to say it just for the sake of saying it, because I'm going to post this on YouTube. If you want to go back and look at it, or if it's information, it's going to be on YouTube, and it's also going to be on our website, thechildsupporthustle.com. But you want to need the docket number, which is ACF-2020-0002, or the regulatory information number, which is 0970-AC87. And then you'll submit your comments to regulations.gov and look for this regulation change. All comments must include the agency name, docket number, and be advised that your personal information, if you do it via email or if you mail something in, which the mailing address is Office of Child Support Enforcement, Attention Director of Policy and Training, 330 C Street, Southwest, Washington, D.C. 20201. So keep in mind that your information will be published, and your comments should be specific, address issues raised in the proposed rule, and explain reasons for any objections or recommended changes. So even when you go in and say, don't do this because this is going to raise our parents' debt, or however you present it, give reasons why this is wrong, and recommend what they should do. And we say defund child support. That's what we say here. Hold these people accountable. There's a lot of talk about the Supreme Court and electing judges, but if the Supreme Court makes a ruling like they did in Turner versus Rogers, and the states are ignoring the ruling, what's the point? We're going to have to hold the states and these officials accountable. And yes, this includes the child support system. Non-custodial parents, fathers, mothers, non-residential parents should not be treated as second-class citizens, and sometimes even less than second-class citizens. The Constitution should not apply when it's convenient for the state and violate people's rights just for $1 that most of these kids are not going to see. So that was a lot of information. I'm so sorry it took so long. I like to give the information and then add my own stuff to it, but this was So it's regulation, and it's so very important. I wanted to make sure I didn't miss anything. So if you left, you know, in the middle of it, I understand. Hopefully you'll come back and watch it. Hopefully you'll click share, or you've already shared, and I appreciate the ones that stuck with me. Thanks, Brad. Thanks, Kyle. Yeah, you guys were my ride or die. Y'all been here the whole time, so I appreciate y'all. No, they don't care, but we're gonna make them care. Like we did when we did the protest across the states. We did get turnout, but we didn't get the turnout that we have to have if we want these people to pay attention. It's got to be 1 million of us in the streets, and we are on the right side of history. Make no mistake about it. This has got to change, and there is a shift. I see it. I've been advocating for a long time, and I see they don't publicize the shifts and the changes in the law, the guidelines, or when they change, but they'll publicize when somebody's an alleged deadbeat, or when they do child support sweeps, but they won't talk about, oh, you can't arrest somebody because of this, or you can't take somebody's license because of that. They'll rescind the letters, like the letter I posted today, the DOJ letter. They'll rescind that in the dark of the night, you know. But there's people like myself and others that pay close attention to what the government does as far as child support. So that's why I like to, and my team likes to bring this information to you all, so it's front and center, because they like to bury all this. So they bury it, so you get tired and you just say, you know, F it, I'm not doing it anymore. Thank you guys. As a fellow disabled veteran, they definitely need to know their rights, as far as if they're just receiving disability compensation, that money is supposed to be exempt from garnishments for child support. The only way that they are supposed to legally garnish that money is if retirement money is included in your disability compensation payment. I did check the childsupporthustle.com. I wrote an article about that, and there's a lot of links, resources there. So check that out, Donovan, and see if that can help you, or help some of your vets that you know. Okay, guys, I'm gonna get out of here. I have to go cook dinner. Yeah, my dad's recovering from open heart surgery, so that's why I haven't been able to be on and do more videos, but that's going to be my focus. So I'm going to start getting more information and putting it out and making more videos, so I can get really comfortable with, you know, being in front of and talking to you all, so we can communicate more freely. And so okay, so thanks everybody for watching the video. Don't forget, you can order the Child Support Hustle, my book, at thechildsupporthustle.com. Get a t-shirt, support the movement. All proceeds are reinvested into the movement. So yeah, I thank you all for your continued support, and remember, they can ignore hundreds, they can ignore thousands, but they cannot ignore millions. Look outside. Let's go.